companies. So today's session we will be studying the winding up. So let us now proceed further with it. So winding up of company is we will be studying the introduction, what is the main purpose of winding up, and difference between winding up and dissolution. This I am not taking here because not required. Various modes of winding up, compulsory winding up, voluntary winding up. Actually, winding up by tribunal actually comes in this compulsory winding up itself, because this is why I have just given it over here, is because there is a distinction between the Act of 1956 and the recent act of this Companies Act 2013. Okay, so that's why, because previously it used to happen like that only. So in the words of Professor L.C.B. Grover, winding up of a company is a process whereby its life is ended, its property administered for the benefit of its creditors and members. Okay, so whatever property the company is having, it is distributed among the creditors and the members. Members are the shareholders, but creditors are given the first right in order, because they have given the credit to the company. So their first right will be there in order to get the property distributed at their names, right? In layman language, winding off a company is a process of putting an end to the life of the company. It is a proceeding by means where the company is dissolved, the assets are collected, debts are paid off out of the assets of the company or from the contribution by its members if necessary. Now what happens? So if the assets are being created by the funds of the shareholders, or you can say if the company is with shareholders, then what will happen? All the debts will be paid, all the assets will be sold off, and all the debts will be paid, and remaining, if so ever surplus is there, then will be distributed among the shareholders as a final dividend, and it will be closed down. But in case if the company is limited by guarantee, so in that case what happens, the members will have to contribute. If there is any deficiency occurs, then the members of the company have to contribute to this all kitty, and then only the things will happen. Means in that case, if the members contribution is required, it means the members will not get anything else. And further, sometimes it also happens that the surplus may be remaining. So in case if it is a company not for profit, then there are the methods of disposal of that surplus separately, right? So if any surplus is left, it's distributed among the members in accordance with their rights. But if the company is not for profit, then there are certain other provisions which can be considered for disposing of the surplus if any arises. So in the more elaborated way, it is a process by which the management of the company's affairs is taken out of its director's hand. So who are the people who are managing the company's affairs? These are the directors which are appointed particularly for managing the affairs of the company. Now they are actually, because the company is going to be wound up. Now the affairs will be taken out of the hands of the directors. Its assets are realized by a liquidator. So who will be appointed? So liquidator will be appointed in order to sell off the company as such. So assets will be realized by the liquidator, and its debts are also realized. Means debts are if the debts are also there, so debts will be collected from the you can say the debtors of the company, and the liabilities are discharged out of the proceeds of these two realizations. Means the liquidator and the fixed assets and the debts are collected, and the liabilities are paid off. And surplus, if any of the assets is remaining, then it is returned to the members or the shareholders. Now, who is a liquidator? Liquidator is an officer which is appointed either by the court or decided in general board meeting of the company when the company goes into winding up. Okay, so when the company goes into voluntary winding up, then this is decided in the general meeting, and liquidator is responsible for collecting all the assets of the company and setting all the claims against the company before putting the company into dissolution or winding up. So what is the main purpose? So why this winding up of company is necessary? The main purpose of the winding of the company is to realize the assets and pay the debts of the company as early as possible. So it's a process to expedite the realization of the assets and payment of the debts, and it has to be done in fair manner, okay, in accordance with the law. However, the purpose must not be exploited for the benefits or the advantage of any class or persons entitled to submit the petition for the winding up. So what happens that it has to be fairly done. So it should not be actually, done in order to just give benefits to someone and or exploit or you can say put someone at the disadvantage. So it may be noted that on the winding up, the company does not cease to exist as such except when it is dissolved. So on the winding up, the affairs of the business of the company will be wound up. But in order to just clear the company, or in order to you can say it is what is. So registration is a process of when the company takes birth. The winding up and the dissolution is a process when the company is put to an end. So when the business of the company is put to an end, it is called winding up, and when the company itself is put to an end, then it is called dissolved. So I asked you a question whether the company will be able to start its business after the business has been wind up. Yes, the company can start because the company has not yet died. It is an artificial legal person which is created by law. It can be killed by the process of dissolution further. Okay, so process of dissolution actually includes the removal of the name from the register of the companies kept by the registrar. So still the time company's name has been removed from the register maintained by the registrar, it will still be in existence. It happens by the process of dissolution. Okay, so the administrative machinery of the company gets changed as the administration is transferred in the hands of the liquidator. So entire administration is now, directors will be normal shareholders and all the things will come in the hand of the liquidator. The property and the assets of the company belong to the company until dissolution takes place. On dissolution, the company is no longer exists as a separate entity and becomes incapable of keeping any property, suing, being sued, because there will be no existence at all of the company as such. But till the company is wound up, still the things will be in the name of the company itself. Okay, so everything will be given to the and the liquidator, like directors are to take care of the company while the companies are going concern. Liquidator is appointed in order to treat the company, or in order to set the company as a for its closing, right? So let us say about the modes of winding up. So legal provisions for the winding up the company, and so section 294A of the Companies Act 2013 provides the following definition of winding up. Winding up means winding up under this act or liquidation under the Insolvency and Bankruptcy Code 2016 as applicable. Now what the thing is, the provisions of winding up has been drastically been changed by the Companies Act 2013, as these were before in Companies Act 2000. Companies Act 1956. Okay, so these have been, there has been a drastic change, and in the last 7 years, means since 2013 to 2020, these provisions have been kept on changing. From means there was a lot of confusions regarding certain things, and this Insolvency and Bankruptcy Code came in existence in 2016 only. So what used to happen in between, if the companies have to wound up into from 2013 to 2016, so there were certain provisions which were made out of the Companies Act 2013 and were not made, though the provisions were declared, but were not applicable as such. So after this passing of this Insolvency and Bankruptcy Code 2016, certain provisions were applicable, and then only these came into existence. So the procedure of winding of companies are provided under Chapter 20 of the Companies Act 2013 and Insolvency and Bankruptcy Code of India 2016. So this is to be remembered, that you have to the definition of the winding up is given under Section 294A, and 2020 is the you can say this chapter 20 is the chapter in which the process is completely given, along with the Insolvency and Bankruptcy Code IBC 2016. So Insolvency and Bankruptcy Code 2016 is an act to consolidate and amend the law related to reorganization and insolvency resolution of a corporate person, partnership firm, and individuals in the time of winding up, or you can say it has to happen in a time bound manner. So it is it is so done for maximizing the value of the assets of such persons, or to promote the entrepreneurship, availability of the credit, and balance the interest of all the stakeholders. Because sometimes what happens when the winding up things are going on, because company will not be in existence afterwards. So during the time of the winding up itself, what happens that some people actually take advantage at the disadvantage of others and make their personal profits. So this particular process in IBC code 2016 ensures that these type of hanky-panky things should not happen. Okay, so it is done for maximization of the value of the assets of all the stakeholders, and to promote the entrepreneurship, availability of the credit, and balance interest of all the stakeholders, including alteration and in the order of priority of payment of the government dues, and to establish an insolvency and bankruptcy board of India, and for the matters connected there. So remaining this you can say definition is not that much, but you just remember that why this is established. Okay, so IBC was passed by Parliament on 11th May 2016, received the presidential consent on 28th May 2016, and was notified in the official gazette on the same day. So let us now discuss about the modes of winding up a company. So now is it clear to all of you that the Companies Act 2013 Chapter 20 read with Insolvency and Bankruptcy Code of India 2016, both of these will decide what will be the process and how the things will go on in case of winding up. Any problem if you have up till here, you can just ask me or you can tell me. Otherwise, should I proceed further? Saurabh, any question you want to ask? Shreya, Sanya?
No, sir.
Rita?
No, sir.
Should I proceed?
Yes,
No,
sir.
sir.
No?
No, you can proceed, sir.
Okay, thank you, thank you. Fine. So modes, I have already told you, it is by tribunal, or you can say it's a compulsory winding up or a voluntary winding up. So two modes are there under Companies Act 2013 for the winding up. So let us just discuss about the winding up by the tribunal. So section 270 of the Companies Act 2013 provides that the provisions of part 1 of chapter 20 of the Companies Act 2013 shall apply to the winding up of a company by tribunal under this act. So circumstances in which the company may be wound up by the tribunal. So section 271 of the Companies Act 2013 provides that a company may, on a petition under section 272, be wound up by the tribunal under the following circumstances. A, if the company has, by a special resolution, resolved that the company will be wound up by the tribunal. So this is the first thing, that company itself has resolved that it needs to be wound up by the tribunal only, then the tribunal will take action. Second, if the company has acted against the interest of sovereignty and integrity of India. Suppose a person has created a company in order to deceive the government, or a person has created a company in order to play with the security of the state, security of in India, or it has created a company just in order to increase the you can say terrorism in the country, or just to have a shaked hand with the Chinese government or something like that, and doing something which is against the integrity and sovereignty of India, or you can say it adversely affects the foreign relations of the company, or any immorality, or any anything which is against the public policy and which distorts the public order. In that case, the tribunal may decide to wind up the company. It is one of the powers of the tribunal also, you can say. Second is, if on an application made by the registrar. Now, who is the other person? Registrar can also file an application to the court for you can say to the tribunal for winding up of the company. So if on an application made by registrar or any other person authorized by central government by the notification under this act, the tribunal is of the opinion that the affairs of the company have been conducted in a fraudulent manner. So when it will happen? When the registrar has filed the application and he is having a sufficient proof to show that the affairs are conducted in a fraudulent manner, or company was formed fraudulently or for a lawful purpose, or the person concerned in the formation or the management of his affairs have been guilty of fraud, misfeasance, or misconduct in connection therewith, and that it is proper that the company should be wound up. So they have to give a proper reason. In such case, the onus of proof will be to the registrar. So registrar has to prove that the company is not doing certain things in a correct manner, or it has been formed by the fraudulent way. So it may apply the tribunal for the winding up of such company. Next, if the company has made a default in filing with the registrar its financial statement or annual returns for immediately preceding 5 consecutive years. So if the if proper returns have not been filed with the ROC by a company for 5 consecutive financial years, the registrar may take an action against the company for winding up of the company. Next, if the tribunal is of the opinion that it is just and equitable that the company should be wound up, then it again has to prove it in the court of law that why he considered it to be a just and equitable. No, so those things has to be proven in the court of law. So in all these circumstances, you can say the winding up can happen to the tribunal. Okay. So petition for winding up. So how to file a petition for winding up? So section 272(1) of the Companies Act 2013 provides that subject to the provisions of this section, a petition to the tribunal for the winding up of the company shall be presented by the company itself. Okay. One A and B by the company and the contributors combinedly. Okay. I think there is a bad network problem anyways. Fine. Next is either it can happen by the registrar of the companies or any person authorized by the central government in this behalf, or in case falling under clause B of section 271 by the central government or the state. So even central government and state government, if they are also of the opinion that the company may be wound up, they can also file a petition to the tribunal for winding up of the company. So here central government and state government will also be under the judiciary. Okay, they cannot do the things by their own. So they also have to file a petition to the tribunal for the winding up of the company. So a contributor shall be, who is a contributor? Contributor shall be entitled to present a petition of the winding up of the company, notwithstanding that he may be holder of fully paid up shares. So contributory means a person who has actually contributed in the assets of the company, or that the company may have no assets at all, or may have no surplus assets left for the distribution among the shareholders after the satisfaction of liability, and the shares in respect of which he is contributory, or some of them are either originally allotted to him or have been held by him and registered in his name for at least 6 months. So a person who has been in the list of the members of the company for preceding 6 months will also be called as a contributory during the 18 months immediately preceding for the commencement. So whenever there is a date of winding up, so in last 18 months, if a person has hold the shares at least for 6 months continuously, or 6 months in breaks whatsoever, so he will also be called as a contributory for the purpose of this winding up. So it means that any contributory can also apply for the winding up of the company, because he is a person who has been in a close association of the company. The company may have expelled him, the directors may have expelled him, but still he is having all his rights in order to initiate the winding up procedure. So that's why the time period, in the time period of last 18 months, there will be one means in last 18 months the contributors have can do it for continuously for a period of 6 months. Yeah, just a moment. Yeah, guys. So within 18 months, a person has to be the member of the company for 6 months or so. Then he will also be having a right as a contributor to initiate the winding up procedure. Right? Any doubt in this? You guys do not have any doubts. I know very well. So the registrar shall be entitled to present a petition for the winding up under section 271, except on the grounds specified in clause A or clause E of the subsection. The registrar shall obtain the previous sanction of the central government to present the for the presentation of the petition of winding up. So one approval from central government is also required to be taken. So the central government shall not accord its sanction unless the company has been given a reasonable opportunity. So what will happen if the registrar has to apply for the winding up of the company? Then the registrar must give first so registrar must give first an opportunity of being heard by the company and opportunity to make the representation that why their company should not be wound up in front of the registrar, and the registrar has to record those things in writing, and then only can approach the central government for filing a petition that the company should be wound up. Okay, so a petition company for winding up before the tribunal shall be admitted only if accompanied by a statement of affairs in such a form and in such a manner as may be prescribed. So a copy of the petition made under this section shall also be filed with the registrar, and registrar shall, without prejudice to any other provision, submit his views to the tribunal within 60 days of receipt of such petition. Okay, so these are the things which have to have happened, because this is something which is called the process of winding up by the tribunal. So for all of you, there will be a assignment that you have to prepare a flow chart for winding up of a companies by both the methods. Okay, just refer to my these slides or my video, which will be available online to you always. So you can just see this, and you have to submit the assignment by end of this week. Shreya, please note it down, right? And just put it in the
Yes,
group also,
sir.
Shreya, so that
Yes,
everyone
sir.
should prepare their own presentation, you can say. And that has to be a handwritten one. Okay, so you have to prepare a handwritten process of complete winding up of the company by tribunal and by the by self also. So what are the powers of the tribunal? Powers of the tribunal, just now we have also seen that the section 273 of the Companies Act 2013 provides a tribunal, means what tribunal can do. So on the receipt of the petition of the winding up under section 272, pass any of the orders which are as follows: dismiss it or with or without cost, make any interim order if it thinks fit. It may appoint any provisional liquidator of the company till making of winding up of the company, make an order of winding of the company with or without cost, or any other order as it may think fit. So these all are the powers of the tribunal after getting a petition from the company for the winding up of the company. Okay, so and if it thinks so what order it can give? An order under this subsection shall be made within 90 days from the date of the presentation of the petition. So within 90 days, this order has to be done, and the tribunal has all these following powers to undertake. So before appointing a provisional liquidator under clause C, the tribunal shall give a notice to the company and afford a reasonable opportunity to it to make its representation, if any, unless or special reasons to be recorded in writing, the tribunal thinks to dispense with such a notice. So now this is the second representation. So first representation can be held in front of the registrar, and then second representation can held in front of the tribunal. Now at the same time, you can just think of that what type of objection registrar or tribunal may have. If a company wants to get it wound up, then what is the problem in why we are stopping it, or why so much of presentation is to be done? So now reason of this is that sometimes what happens, people actually create the company to deceive the public, to deceive certain things, or even to to just play around with the legal provisions of the act for their own personal benefits. They may have created a company as a special purpose vehicle just in order to collect money, or money laundering purpose, or all any of the illegal purposes. So in that case, once the company is created, the directors are bound by it. Okay, so directors, and if the winding up process would have been so easy, they would have done it and they would have quitted the company like anything. Okay, they would have used the company, its legal entity, for the purpose of their own benefits. So that's why these all things are to be done. Even if so, there can be two types of frictions can happen. Okay, so one friction is that the members want to wind up the company, but the government doesn't want it to wind up the company, so they have to present it accordingly, why your company should be wound up. And at the same time, second thing is government want to wind up the company because the company is not doing well, and the members, because they do not want to wind up the company, so again the presentation has to be there. So both the types of things have to be there, both the types of frictions are there, which have to be, born at the time of. So I was appointed as a company secretary of uh, uh, this Ashirvad Telenetwork Private Limited in order to wind it up. So I have experience of presenting the company in the front of the court of law. At that time, this tribunal was not made. So I made a presentation in front of a company law board. And this is long back in 2008 and 9 it happened. And then anyhow, I was able to wind up the company. And two times I have to go and just give my representation that why the companies are required to be wound up. So in that case, what happened that all the members of that particular company, they actually want to wind it up because the company was actually not running in a proper way. So that's why the company got wound up. So there are many other confidential things because I can't tell you now because I have already taken the name of the company itself. So there were certain things which are not to be disclosed and confidential. So I will not speak it over here. But if you come in person, then definitely I will be able to tell you that with that and how I just get rid of it. So that was a very good practical exposure which I had, and two times I went to the Delhi for this the CLB proceedings over there. So this is what is so it can write in writing the reasons why it thinks fit. Okay, so the tribunal shall not refuse to make any wind up order on the ground only that the assets of the company have been mortgaged or the amount equal to or excess of those assets. That means financial reasons are not at all sufficient for a tribunal to order for the winding up of the company. Why? Because in such a case, the government also sees that it is very difficult to start up a company, and we are at present we are looking forward for good startup, and when a company dies, so a economic person which has been created by the as an artificial person by the die along with. So that's why it is always seen that it has to be just an equitable type of thing, that how the tribunal feels that the company should be wound up. So that is also one of the things which government has taken a positive action on it, that the company which are having some potential to do some good business should not be dissolved as such. So, Section 273(2) of the Companies Act 2013 provides where a petition is presented on the ground that it is just and equitable that the company should be wound up, the tribunal may refuse to make an order of the winding up if it is of the opinion that some other remedy is available to the petitioner and that they are acting unreasonably in seeking to have the company wound up instead of pursuing the other remedy. So all the possibilities to revive the company has to be seen by the tribunal before ordering the winding up of the company, because tribunal also has to close down its own proceedings, and it has to show the government that how less they are able to wind up the company as such. Next is about the company liquidator. You know very well that when it is to be appointed, when it has been decided that the tribunal will go for the winding up of the company finally, then section 275 1 and 2 of the Companies Act provides that for the purpose of winding of the company by the tribunal at the time of passing the order of winding up shall also appoint an official liquidator or a company liquidator. Provisional liquidator or a company liquidator shall be from amongst the insolvency professional registered under Insolvency and Bankruptcy Code. So all the company secretaries, those who have passed one exam of being an official liquidator, they can be appointed as an official liquidator for closing down the company. So now voluntary winding up process. So up till here, it was the winding up by the tribunal, or you can say compulsory winding up of the companies. Now, voluntary winding up process. So, Chapter 5th of the Insolvency and Bankruptcy Code of India 2016, which deals with the voluntary liquidation of the corporate person. Section 59 of IBC 2013, it says that 59(1) says that a corporate person who intends to liquidate itself voluntarily and has not committed any default may initiate a voluntary liquidation proceedings under the provisions of this chapter. So it is important that default would not have been committed by that person. It means that particular company which has not made any default can proceed further. So the voluntary liquidation of a corporate person under subsection 1 shall meet such conditions and procedural requirements as may be specified by the board. So without prejudice to subsection 2, voluntary liquidation proceedings of a corporate person registered as a company shall meet the following conditions. Now, what are the conditions which are to be met? So first is a declaration from majority of the directors of the company verified by an affidavit stating that they have made a full inquiry into the affairs of the company and they have formed an opinion that either the company has no debt or that it will be able to pay its debt in full form. The proceeds of the assets to be sold in voluntary liquidation and the company is not being liquidated to defraud any person. So this is a statement which is to be given. So previously these statements were not there. In the Act of 1956, these type of undertakings were never taken from the directors, which has been now made mandatory. Actually, at that time the undertakings were taken, but it was means some registrar used to take the undertaking, others do not used to take, and these type of things were not there. But in this particular Act of 2013, it has been made mandatory that such type of affidavit is to be issued by the directors of the company. Next is the declaration under clause A shall be accompanied with the following documents. So they have to provide the documentary proof. Not only the declaration, but a documentary proof is also to be taken. What? Audited financial statements and record of the business operations of the company for the previous 2 years or for a period since its incorporation, whichever is later. Okay. So a period, suppose for example, a company has been incorporated for 5 years. So it will submit last 2 years statement of financial statements and other statements of income and expenditure and other that. Okay. So a report of valuation of the assets of the company should also be prepared and which has to be prepared by the registered valuer. That also has to be submitted as a along with the declaration as an annexure. So what happens then? Within 4 weeks of such declaration under subclause A, there shall be a special resolution of the members of the company in meeting requiring the company to be liquidated voluntarily and appointing an insolvency professional to act as a liquidator. Now if please see it carefully, there is a flow chart going on. So if you properly see it, there will be flow chart going on in your mind for which you have to do the homework of today's lecture. Okay, then after the special resolution and appointment of the liquidator, a resolution of the members of the company in general meeting requiring the company to be liquidated voluntarily as a result of expiry of the period of its duration, if any. So if the company has been formed for a certain period of time, so expiry of period is a sufficient proof for the company to be wound up. So fixed by the articles on occurrence of any event in respect of which the articles provide the company shall be dissolved. If occurrence of any event is there, which articles is providing that the company should be dissolved on occurrence of that event and that event has occurred. So the description of that event has to be provided in the resolution as the case may be, and appointing a insolvency professional to act as a liquidator should also be there in the resolution itself. Okay. So provided that the company owes any debt to any person, creditors representing 2/3 in the value of the debt of the company shall approve the resolution passed under the subclause C. If it is under this, then it has to be passed, and within 7 days of such resolution, this can the resolution can further be filed. So these are the things which have to be. So you have to be careful while regarding the preparation of your process of winding up, because for both separately for voluntary winding up and separately for winding up by tribunal, you have to give the complete flow chart. Okay. Next is the company shall notify the registrar of the company and the board about the resolution under subsection 3 to liquidate the company within 7 days of such resolution or on the subsequent approval by the creditor as the case may be. Okay. Next is subject to the approval of the creditor. So now this is again the steps are already given, but you have to now prepare it in the form of a flow chart. Subject to the approval of the creditor under subsection 3, the voluntary liquidation proceedings in respect of the company shall be deemed to have commenced from the date of passing of resolution under subclause 3 of subsection 3. So now recently we have seen that the who is more powerful? Shareholders are more powerful. So when they have taken a decision in the general meeting, so the date of taking decision in the general meeting will be deemed to be the date of the passing of the resolution will be deemed to be the date of voluntary liquidation proceedings being commenced. Okay. Further, the provision of section 35 to 53 of chapter 3 and chapter 7 shall apply to voluntary liquidation proceedings of the corporate person with such modification as necessary. So you can put this point as a note. Okay, where the affairs of the corporate person have been completely wound up and assets completely liquidated, liquidator shall make an application to the adjudicating authority for dissolution of such corporate person. So if it is dissolution is required, then this is a further process. Okay. And then further, the adjudicating authority shall, on an application filed by the liquidator under subsection 7, pass an order that the corporate debtor shall be dissolved from the date of that order, and the corporate debtor shall be dissolved accordingly. Okay, so the copy of an order under subsection 8 shall within 14 days from the date of such order be forwarded to the authority with the corporate person with which the corporate person is. So this is regarding the means the tribunal will give the order to the registrar of companies. That is the corporate person with whom the corporate is registered. So the registrar of the respective state will get an order that the company has been wound up, and accordingly what will happen? They will remove the name of the company from their registers after the dissolution process is over. So now these are further certain rules which have come up recently and are applicable from 1st of April. But what you can do is because this is not a part of your syllabus, so we can skip it. But still, I have kept it in the presentation itself so that you can actually just go through this. So the company's winding up rules 2020 is there. So you may even go through this yourself too, or otherwise, because these are certain things which are related to what we have just now studied. So there are certain notification that up to what. So these things, if you have to practice, then you have to go for all these things. Otherwise, it's not that much required. But yeah, you can just go through it. That's why I'm showing it for a sufficiently long time, so that it gets recorded in the in our video also, which is being prepared, and then afterwards you can just have a look of it if you want to just have it. Otherwise, this is all about the valuation of the things, and they have set some limits regarding certain things, and other procedural aspects are there which can be just be viewed, or you can say you can just see it, or you can just have an overlook of it. Okay, so this is all about your today's session of winding up. So I have wound up this winding up, but I want all of you to just prepare this complete process of winding up in both the cases, so that the things actually will be in your heart and soul. So that this is one of the very important thing which you must remember. Actually, this winding up itself can take about a month to teach. But this is something which I have just now taken out as a crux and will have given to you, so that you are able to make out the things which we have already studied, and you can relate the things with those. Okay, so this is all about today's class, and then we will proceed further with certain other things in your upcoming classes. So let me take the attendance. Please say yes, sir, if you are present. So Asta Khandelwal, Abhigyan Gupta,
Yes,
Aditya,
sir.
Ankit,
Yes, sir.
uh, Arpan Mishra,
Yes, sir.
Abhigyan Gupta, Aditya, Arpan Mishra, Ashutosh Maharshi, Ashmit,
Yes, sir.
Ayush
Yes, sir.
Botra,
Yes, sir.
yeah, and Ritik Bharadwaj, Ishpreet Singh, Janvi
Present,
Singh,
sir.
Yes, sir.
Jamima,
Yes,
Karan
sir.
Agarwal, Kaushal Agarwal, Meghna Dhuria, Naman Jalan, Naveen Chandlani,
Present,
Navya
sir.
Singh, Neha Singh Rathod,
Present, sir.
Pritam Milan,
Present,
Rajat
sir.
Pate, Sambhav Garg, Sanya Kanwar,
Present, sir.
Present, sir.
Sarfaz Sinha, Saurav Yadav,
Present, sir.
Rahil
Present, sir.
Chauhan, Shara Khan, Shreya Dharan,
Present, sir.
Shubham
Present,
Singh,
sir.
Present,
Tushar
present.
Khandelwal, Vanshika, Vatsal
Yes,
Rastogi,
sir.
Present,
Yash
sir.
Chaudhary,
Present, sir.
Yashvardhan Tiwari.
Present, sir.
Okay, guys. So yeah, Naman, you have some question? You have raised your hand. Neha Singh, yeah.
Sir, present.
Okay, that's why you raised your hand. Okay, I hope I have taken your name, right? Fine. Anyways, चलिए ठीक है. So let's meet tomorrow. Okay, because tomorrow also I have rescheduled your class. So tomorrow we will meet for the class for this particular week. Okay. Thank you. Have a nice day. Stay safe and stay healthy.
Thank you,
Take
sir.
care.
Have a
Bye-bye.
nice day, sir.
Thank you, sir. Same to you, sir.
Thank you.
Have a
Thank you.
nice day, sir.
Thank you, beta.